You've heard the whispers, haven't you? Marriage green cards are getting brutally harder to obtain. The headlines scream about waivers under siege and a wealth test making its comeback. But here's the problem. Nobody's breaking down what this actually means for you right now. If you're married to a U.S. citizen or about to apply, listen carefully. The way the government evaluates your history and finances could be the difference between approval and being stuck outside the country indefinitely. I'm John from Dream Visa Updates, and today I'm cutting through the noise to show you exactly what's happening in late 2025, heading into 2026. What's changed, what's coming, and most importantly, what you need to do right now to protect your green card application. Stay with me because what I'm about to reveal could save your family years of separation. Let's talk about what's actually shifting with marriage green cards. The tightening around waivers and the resurrection of a much tougher wealth test could completely derail your immigration journey. Here's where we stand. We're deep into President Trump's second term, and immigration has roared back to the top of the priority list. But it's not just border enforcement anymore. Legal immigration, including marriage-based cases, is under intense scrutiny. First, waivers are under massive pressure. Now, the laws allowing waivers for unlawful presence and certain misrepresentations, they still exist. Forms like I-601 and I-601A are still available. But here's the catch. Processing is agonizingly slow. Scrutiny has skyrocketed, and there's serious conversation in Washington about strangling this relief even further. Second, the public charge wealth test is being revived in stages at U.S. consulates overseas. Fresh State Department guidance is now instructing officers to examine an applicant's health and finances with a microscope when deciding if they might become a public charge. And get this. DHS has already kicked off the process to completely rewrite the public charge regulation for green cards inside the United States. We could be looking at something eerily similar to the brutal 2019 wealth test. Let me break down waivers for you. A marriage-based waiver is your legal safety net. If you're married to a U.S. citizen but your immigration history has some damage, like overstaying in the United States without permission, a waiver can still get you that green card. But there's a condition. You must prove your U.S. citizen spouse would suffer extreme hardship without you. These waivers are typically used by people who've been in the United States illegally for more than 6 months, triggering those dreaded 3 or 10-year unlawful presence bars. Or maybe you entered without a visa or dealt with certain types of misrepresentation. Here's what you need to understand about late 2025. The waiver laws themselves? Still on the books. But the way these waivers are being processed, that's where everything's gotten significantly harder. Forms like I-601A haven't been killed off like the rumor mill suggests. USCIS even released a new edition earlier this year. But don't let that fool you. Here's what has fundamentally changed. Extreme delays mean provisional unlawful presence. Waivers now take roughly 30 to 36 months just to get a decision. 36 months. Policy guidance issued in 2025 emphasizes that people losing their status are far more likely to be thrown into removal proceedings. Deportation proceedings. Immigration attorneys are seeing more notices to appear after unfavorable outcomes. DHS has publicly declared it's closing loopholes and restoring integrity to legal immigration. Translation? Officers are being pushed hard to apply the law more strictly than ever before, so when people fear waivers could vanish entirely, that fear isn't baseless. But right now, as we speak, they still exist. The risk? They're slower, harder to obtain, and far more fragile than they were just a few years ago. Let me paint you a real picture. Meet Maria, a U.S. citizen, and her husband George from Honduras. George crossed the border without a visa back in 2012. He never fixed his status to become legal, but he's been working, paying his taxes, and raising 2 U.S. citizen children with Maria. Today, Maria can still petition for his green card. But here's the brutal reality. George will trigger a 10-year bar the moment he leaves the United States to attend his U.S. Embassy. Interview. He'll need a provisional unlawful presence waiver before that interview at the embassy. They'll have to prove Maria would suffer extreme hardship if George gets stuck outside the United States for years. Or imagine this: Maria and her kids having to uproot their entire lives and move to Honduras just so George can wait out that 10-year bar. Here's the difference in late 2025. That waiver could drag on for 3 years or more just to get a decision. While their case sits in limbo, policy changes make it far more likely that any mistake could trigger removal proceedings. And if future regulations narrow these waivers even further, families like Maria and George could lose this option completely. The door hasn't slammed shut yet, but it's closing fast, and the path through is getting riskier by the day. If you've already filed for a waiver, your case is still alive. There's no law automatically canceling I-601 or I-601A waivers right now, but brace yourself for long waits, 30 to 36 months, sometimes even longer. If USCIS has issued a request for evidence or a notice of intent to deny, understand that scrutiny has intensified. Expect more detailed, invasive questions about hardship, finances, and your prior history. If you haven't started yet, waiting too long is a gamble you might lose. Not because waivers have disappeared, but because future rules could narrow who even qualifies. What you do today, right now, could determine whether your family has options if the rules tighten in 2026. Now let's tackle this wealth test, officially called the public charge rule. Public charge has been woven into United States immigration law for over a century. It's not new. It allows the government to deny someone a visa or green card if that person is likely to become primarily dependent on certain government benefits. Here's the current landscape. Under Biden in 2022, DHS issued what they called a fair and humane public charge rule. That rule only counts certain cash assistance programs and long-term government-funded institutional care. That rule is still technically in effect today for green cards processed inside the United States. But in 2025, Trump signed an executive order commanding federal agencies to tighten eligibility checks. The State Department has now issued fresh guidance to consular officers abroad. They're being told to consider health conditions like diabetes, obesity, cancer, mental health issues, along with a person's long-term ability to pay for care. And DHS has sent a new public charge regulation to the Office of Management and Budget. That's the first critical step in rewriting the rule for adjustment of status cases inside the United States. So, is this wealth test actually back? For people applying at consulates abroad, a tougher health and wealth-focused public charge analysis is already here. For people adjusting status inside the United States, the older Biden-era rule is still in effect right now, but DHS has clearly begun moving toward something much stricter. If you're applying for a marriage green card, you're now facing 2 layers to think about. First, the Affidavit of Support, Form I-864. Your U.S. citizen spouse must prove sufficient income, usually at least 125% of the federal poverty guidelines, and sign a contract promising to support you. That requirement hasn't gone anywhere. Second, the broader public charge analysis. Inside the United States, USCIS still uses the 2022 rule, looking at household income and certain cash benefits. But at a U.S. consulate abroad, officers now have a new directive telling them to dig deeper. Serious or chronic medical conditions, your ability to pay for care over your lifetime, your education, skills, English level, and any past use of public assistance. If they decide you're likely to rely on government support at some point down the road, they can deny your green card, even if your sponsor technically meets the poverty guidelines. Let me give you a real-life example. Meet Anna from the Philippines, married to Peter, a U.S. citizen earning about $28,000 a year, just above the poverty guidelines for a household of 2. Under the old approach, they could usually sail through consular processing as long as Peter met the income requirement and the marriage was genuine. Under the new 2025 State Department guidance, Anna's consular officer might scrutinize whether Anna has a chronic health condition, how much savings they actually have, whether they have private health insurance, and whether Anna speaks English or has marketable job skills. Even though their income clears the poverty line on paper, the officer can still decide Anna is likely to become a public charge and deny the visa, especially if they have limited savings and medical risks. If you're worried about waivers tightening or the wealth test getting more brutal, here's what you can do right now. Don't wait blindly, but don't file blindly either. If you're likely eligible, waiting years to start can be dangerous in a system that's changing this fast. But rushing a weak case just to beat a possible rule change can backfire spectacularly. Straighten your financial picture. Gather pay stubs, tax returns, employer letters for your U.S. citizen spouse. Get proof of savings, retirement accounts, property, any other assets. Show evidence of private health insurance or ability to pay for care. Document your education, your training, your English skills. Prepare a serious hardship package. If you need a waiver for I-601 or I-601A cases, you want detailed, compelling evidence of how your U.S. citizen spouse would suffer if you're forced to leave. Medical, emotional, financial, all of it. Work with a qualified immigration attorney. With DHS rulemaking underway and consular guidance shifting, just filling out forms isn't enough anymore. You need a strategy tailored to your processing location, your immigration history, and your financial situation. This is the real heart of the issue. If waivers are narrowed and public charge rules get tougher, more families will face spouses stuck outside the United States after consular denials, long multi-year waits with no guarantee of approval, and higher chances of removal proceedings if something goes wrong. I see families like yours constantly. Good people trying to fix their status the right way while the rules shift beneath their feet. That's exactly why it's so critical to build the strongest possible case while you still have options. Let me clear up some dangerous misconceptions for late 2025. If I'm married to a U.S. citizen, I can't be denied. Dead wrong. You can absolutely still be denied for unlawful presence bars, misrepresentation, or public charge concerns, especially under stricter consular guidance. I'll just wait until the next president fixes it. Maybe. But if a tougher rule goes into effect while you're waiting, you might lose options you have today. The laws don't always grandfather in people who never filed. Public benefits don't matter at all under the current DHS rule. Most non-cash benefits don't count directly. That's true. But certain cash programs and long-term government-funded care do count, and consular officers abroad are now being told to look broadly at health conditions and overall financial strain. Don't rely on rumors or outdated advice. The wrong move can cost you years of separation from your family. Here's what I'm watching closely. DHS's new public charge rule is already at the Office of Management and Budget. Once it's published, there will be a public comment period. Then DHS can finalize it likely sometime in 2026. That rule could make adjustment of status cases look a lot like the 2019 wealth test. We'll also see how consulates apply the new Health and Wealth Directive. Officers have significant discretion, and over the next year we'll see how aggressively different posts use it to deny marriage-based visas. Let me sum this up. Waivers for marriage-based green cards still exist in late 2025, but they are slower, under far more scrutiny, and in the political crosshairs. The public charge wealth test is already tougher for people applying abroad, and DHS has started the process that could bring a stricter version back for green cards inside the United States in 2026. If you're married to a U.S. citizen or a lawful permanent resident and you have immigration issues or limited income, you are in a higher risk category. But you still have options if you act thoughtfully and get the right help. Don't leave your future to rumors or wishful thinking. This isn't just information. This is about your rights, your future, and what you can do next. I'm John from Dream Visa Updates, and I'll see you in the next one where we dive even deeper into what's coming in 2026. Stay informed, stay prepared.